Okay. When you are awarded Social Security disability benefits, does that mean you are adjudicated as mentally ill? And I think I understand what this person's asking. Person goes before, let's go with the court. That's usually the easiest one for me. A judge makes a determination that you get a fully favorable decision based on your condition. And you're asking you if the reason that you were found disabled was predicated on Social Security's, based on your mental health impairment, is the judge making an independent adjudication that you are mentally ill. It's not that clear cut and clean like this, because let me tell you why. The judge is not saying, I have decreed this person is mentally ill. That's really not the way it flows. What it is that the judge is going to, let's follow, let me just kind of work you through the process. What happens is the judge makes a determination that the severity of your condition complies with these 5-step sequential evaluation. Now that's a whole lot of gobbledygook, but what the judge is saying, are you disabled? He is saying that you are disabled. He's entered into a judicial ruling based on his decision or her decision that you meet the criteria of the Social Security Administration and therefore you are disabled. Now, if they ask the question, what impairments did he or she believe were of such severity that renders you disabled? Then, if it's mental health is your primary thing, let's say that you're applying for disability based on depression and anxiety. The judge makes a determination that 1, you've been out of work for 12 months. 2, you have a severe impairment, and that severe impairment that's lasted 12 months or more is anxiety and depression. He or she doesn't believe that you meet the listings of medical conditions to satisfy that under step 3, but under step 4, he or she determines that your depression, anxiety is so severe that you couldn't do anything you used to do, or step 5, that you couldn't do anything else. So this is going to sound goofy. To answer your question based on the way I explained it, you're probably saying, so basically you're telling me that they did. Not in so many words, yes, but not really. Because basically the judge is not saying, I have determined that this individual is mentally ill. I've adjudicated them mentally ill. No, that's not what the judge is doing. What the judge is saying is that you are unable to work due to your disability. You have a severe impairment that disables you from work. So this is and the reason why I say this is this. If you've noticed, and when you look at like when you hear competency hearings and Marchman hearings and Baker Acts and so forth, they're not looking at adjudicating you of a particular standpoint. What they're doing is that they're comparing it against something. Like for instance, let's back it up. I know I'm saying a couple of high technical phrases, but let me make it a little clearer. For instance, in Florida, there is what we call a Baker Act, but in other states it has a different name, but it's called involuntary admissions. Basically what happens is that in some scenarios, if certain providers have a reason to believe, whether it be doctors, dentists, teachers, in some cases, in some places, judges, things like that, if those individuals have a reason to believe that your mental health condition renders you a danger to yourself or others, potentially a danger to yourself or others, you could be involuntarily admitted to a psychiatric facility for 3 to 7 days until your condition stabilizes to you are no longer a threat. Now, have they adjudicated you mentally ill? No. What they've said is, you've got a mental illness that causes this effect. And we believe it's of this severity. We believe that it's of this severity that causes this to happen. So what they're basically saying, you're mentally ill, and we think your mental illness may cause you to hurt yourself or somebody else. Same instance. So the judge is saying you're mentally ill, and we think your mental illness prevents you from being able to work. Now, he didn't say, or she didn't say, your mental illness prevented you from being able to go to the bathroom or go to the mall or go to the grocery store. because that's not what the judge is looking at. The judge is looking at, does your impairment prevent your ability to work? And the reason why I stress this is because when you're saying, are they adjudicating me mentally ill? And I'm like, the problem with making a blanket statement like that is, one, the judge is not making a legal diagnosis, because what you're basically saying is, I'm mentally ill and the court has recognized that I am mentally ill. Well, no, the court is not recognizing anything. The court is saying that the medical evidence supports that you have a severe diagnosis of a condition, and that condition is so severe you can't work. Plain and simple. So I tell people this. So don't go walking down the street with a piece of paper saying, the judge says I'm mentally ill. It's not what the judge is saying. The judge is saying you have a severe mental impairment. The doctors are saying you're mentally ill. The judge is saying that when looking all through your medical records, that your condition is of such a severity, it's so severe you can't work. So I say this to say this. Don't get caught up in what the fact of the nice little bells and whistles, so that you're sitting here, because I know what happens, and I'm not knocking you. You may not be doing this, because I've had clients who've done this. They want to take the document and use it for another purpose. So they want to be able to say definitively that this says this, so that they can apply it to something else. Don't make it difficult. The court has made a determination that your mental health condition prevents you from being able to do work. They're not adjudicating they're not adjudicating your mental illness. They're not giving a sense of legal, they're not giving a legal, I wouldn't say stability or definitive definition, whatever hyper-technical phrase. They're not validating your mental health condition. It's not like the doctor said you're mentally ill and then the judge comes and says, yeah, I agree, you're mentally ill. Or like you see in a criminal context where a doctor says, no, this person can't stand trial because of their mental or their mental capabilities. And then the judge says, I have determined this person is legally incompetent. That's a different context than what we have here. So don't get caught up in the bells and whistles and get caught up in the hyperbole. In the grander scheme of things, what the court is doing is they're not adjudicating or providing legal validity to your mental health impairment. They're basically saying that your condition satisfies the criteria for Social Security to demonstrate that you cannot do work because of your mental health condition. I hope that clears things up a bit.